Uama ke ao kaina I ka pono o Hawaiian Uama ke ao kaina I ka pono
Aloha ahi ahi kako, and welcome to another episode of Kanaka Express. Mahalo for joining me tonight, everyone, because I think we have a super show tonight and information that we're going to be talking about that all of you who own property, whether you own a house, whether you own land, or a commercial building, that you're going to want to hear. Because we've been talking about this for a long time, and in terms of title insurance and defects in title. And so we have Dr. Keanu with us tonight, and he will be explaining to you where the defective titles are and what can be done. Because for the longest time, the courts have, as well as the banks, have ignored the legal arguments that we brought up, or that Dr. Sai has brought up, along with Dexter Kayama has brought up to that presented in the courts, that the titles are defective and they're covered by title insurance. So we're going to dive into that tonight and hopefully answer a lot of the questions, because it's been really interesting. If you haven't read Dr. Sai's the HawaiianKingdom.org/blog, the latest post that was made, it goes into detail on title insurance and what is the history of it, and also what can be done and why. So I'm very excited about bringing on Dr. Sai tonight. And again, he is the agent for the Hawaiian Kingdom, and he has a PhD in political science, specializing in U.S. constitutional and Hawaiian Kingdom constitutional law. And the legal arguments, or the legal fare that we're engaging in, is unique, and I believe is going to lead us to the promised land. We need to go to the promised land, and it's Dr. Sai that is providing all of that information to us. And it's important that every one of us gets educated. We read up, watch some of the videos that we posted, and if you have questions, contact us so that we can ask your question directly. It is important that when you ask the questions, you ask the questions of the right people to get the right and correct answer. So with that, I'd like to also say that my co-host tonight, Kealii, Akina, is not going to be with me tonight. Where he moved to doesn't have access to Wi-Fi, and so hopefully in the upcoming broadcast that we have next week, in the following weeks, that the Wi-Fi issue will be settled. So in the meantime, I'd like to introduce my guest and my friend, Dr. Keanu Sai. Hey, aloha, Keanu, and welcome to the Kanaka Express.
Hey. Aloha, Kealii.
We have quite a few people that have received the invite to join us tonight. And I also read on the blog that there were a lot of comments on the blog, your latest post in regards to title insurance. So I know you wanted to start out with a PowerPoint presentation. So I'm just going to turn it over to you. And then after the PowerPoint presentation, then we'll get into some question and answers.
Okay. So I just want to clarify some things. So I'm responsible for what's put on the blog. I may not necessarily be the one to write it, right? But the blog is put up by the Council of Regency, and it's for informational purposes only. It is not run as a blog, so there's no person moderating the blog. It's purely informational. A lot of things are taking place regarding Hawaii's occupation. Latest issues and still ongoing issues refer to the federal lawsuit, Hawaiian Kingdom versus Biden, which is before two courts. The first is federal court in Honolulu under District Court Judge Leslie Kobayashi, but also it's at the Ninth Circuit Court in San Francisco. And the Hawaiian Kingdom, being represented by Dexter Kayama as the Attorney General, has recently filed pleadings in both cases a few weeks ago. And there has been no response yet by the judge, Kobayashi, or by the Ninth Circuit Court regarding the issue before them, right? What we're doing here is this approach of exposing Hawaii's occupation is very legal. And the legality of things sometimes goes over people's heads, right? To legalese. But the issue of the existence of the Hawaiian Kingdom, its continued existence, and the legal basis for the Council of Regency as the government, the acting government of the Hawaiian Kingdom, is based on law, okay? And facts are used by interpreting it through the law, okay? Now, these same issues with regard to the legality of something also applies to land titles, okay? So land titles cannot just be arbitrarily acquired by somebody. There is a process by which titles are regulated in every country, right? And in our particular situation, titles are regulated by what is called common law, okay? Common law or land tenure, which common law is able to explain, which means court cases begin to identify and clarify what are the rules that apply to land tenure, okay? And here in Hawaii, private ownership of land began in 1845, the formal aspect of property ownership, okay? So what I want to, so as a result of Hawaii's occupation though, it did have and continues to have a direct impact on land titles, okay? When I speak of land titles, I'm talking about private interest of ownership, fee simple titles, leasehold, or life estate, okay? So what I want to do is I want to present a PowerPoint that I feel should be enough to get the main points across. And again, this talk that I'm having is clarifying the latest posts on the blog with regard to defective land titles throughout Hawaii. Okay. So with that, why don't I just go ahead and start that PowerPoint. Okay, I just need to check with Kealii. Kealii, can you see the PowerPoint?
Yes.
Okay, perfect.
Yes.
All right, so why don't we begin? The impact of the U.S. occupation on land titles. Well, before we can really understand the impact, we have to understand terms, real estate terms in particular, okay? And there's some confusion here, locally and abroad, even in America, confusing the terms dealing with real estate, okay? Give me an example. So when I ask a person, what does a mortgage mean? And they would say that A mortgage is a loan. Kealii, I think you got to mute yourself. So they say a mortgage is a loan, but it's not. Actually, a mortgage is collateral that secures a loan. These are two different documents. Okay, so a loan here is called a promissory note, which is a written document in which a borrower agrees or promises to pay back money loaned by a lender according to specified terms. The mortgage, however, is a lien, which is a right to keep possession of property belonging to another person until a debt owed by that person is discharged. Okay, so you have a loan, which is a promissory note, which is secured by a mortgage. That is when the borrower conveys the property to the lender as a lien, which is like a collateral, so that the lender can hold on to that property to ensure the repayment of the loan. If the borrower defaults on the loan, the mortgage agreement authorizes the lender to sell the property to recover the debt owed, and that is through what is called a foreclosure process. Okay. Now, if the borrower completes his payments under the loan, let's say for 30 years, once it's completed, then the bank will release the mortgage back to the borrower. And then that borrower will probably use his asset to borrow money again. Okay, so that's the difference between a promissory note and a mortgage. Now, a deed is a legal instrument that is used to assign ownership of real property. So a deed is how you acquire ownership in property. In this case, a fee simple title, which would allow you to mortgage that property to the lender to ensure the repayment of the loan. So here's an example of a promissory note. Okay. So clearly it states the borrower's promised to pay, in this case, $290,000, and the lender is Argent Mortgage Company. Okay. Now here's a mortgage, okay, to Argent Mortgage Company. And it says here, under definition, security instrument means this document. Okay, so the borrower is the mortgagor under this security instrument. Another word for security instrument is collateral. And here's an example of the deed that was used as the basis for the mortgage. Now, before the bank accepts your mortgage, okay, they want to loan the money to you because they make money off of you, off of an interest rate, okay? So there is a business of loaning money and collecting interest. Nothing wrong with that. But before the bank accepts the mortgage, they have to be sure that that person who is mortgaging their title to secure the repayment of the loan actually owns the property. So they require the borrower to go to an escrow company of their choosing and there have the title escrow company provide a title report on that property, that there are no defects in the title. But the bank still won't accept your mortgage until you're able to get title insurance. So the escrow company works with underwriters who represent title insurance companies from America, Chicago Title Insurance Company, Old Republic Title Insurance Company, Thai Court Title Insurance Company. They're not here, but their underwriters are here. Okay, so title insurance is where the insurance ensures the accuracy of the title search, that there are no title defects. So by definition, title insurance is a policy issued by a title company after searching the title, representing the state of that title, and ensuring the accuracy of its search against claims of title defect. Title insurance is an indemnity contract that does not guarantee the state of land titles, but covers loss incurred from a defect in land titles. Title insurance is different from other insurance. So car insurance is insuring against a future event, a crash that may or may not occur. Title insurance insures for a defect that there are no defects in the past that may or may not have occurred. So it's a unique type of insurance. A lot of reliance is on the expertise and training of title abstractors. Now, a defect is the want or absence of some legal requisite, deficiency, imperfection, or insufficiency. Types of deficiencies would be a notary in the chain of title that goes back, in the case of Hawaii, to 1845. The title abstractor may find a defect where the notary that was used, the commission had expired. So they would have to remedy that defect by taking the deed of the past to another notary to get it done correctly. Another type of defect could be in a trust. Instead of the trustee on behalf of the beneficiary conveying property, the title abstractor may find that the beneficiary, not the trustee, was the one who conveyed the property. These are just some examples of defects. Okay. Now, you have two types of policies, though, title insurance policies. You have a lender's title insurance policy, which protects the lender from losses incurred as a result of the defect in title. The lenders require the borrower to purchase a lender's policy at escrow as a condition of the loan. Now, the lender's policy only covers the debt owed to the bank. Okay, so the borrower would purchase the title insurance policy for the protection of the bank and the debt that it has. So if they borrow $300,000, the borrower borrowed $300,000, the lender's policy will initially cover $300,000. But as the borrower pays off the debt owed to the bank, the debt is reducing. So it will be less than $300,000 after a few payments have been made. So the lender's policy coverage only covers the debt owed to the bank, right? And it constantly reduces as that debt is being paid. The second type of insurance policy is an owner's title insurance policy. And this type of policy protects the owner from losses incurred as a result of a defect in title. Now, the amount that is covered in an owner's policy, unlike the lender's policy that only covers the debt and it reduces through time, an owner's policy covers the appraised value of the property at the time the policy was taken out. Okay, so if the owner has a piece of property and it was appraised at $150,000, then the owner's policy has a coverage of $150,000. It does not reduce, okay, but it is the full coverage of $150,000. So here's what a lender's title insurance policy looks like. And this is from Stewart Title Guarantee Company. And here is an example of an owner's policy. And this one issued by Ticor Title Insurance. Now, many people don't even know that they had title insurance or that they have title insurance. And a way to find out is go to your HUD-1 statement or the closing costs of escrow. And there you will find whether or not you have an owner's policy and or a lender's policy. Now, if you have a mortgage, it is guaranteed that your closing costs will reflect a lender's policy, because escrow would not close without the borrower securing the lender's policy. Okay. But The owner's policy is normally taken out the first time somebody goes through escrow, right? And the escrow company recommends that, you're a new owner, you should purchase an owner's policy. Well, that HUD-1 statement should reflect whether or not you purchased an owner's policy. Okay. Now, some people may have gone to different escrow companies because they borrowed money off of their property multiple times. But if you go to the first escrow, chances are you will have an owner's policy. Better yet, if you can't find your closing papers, but you know what escrow company you went to, you can just call them. Whether it's Title Guarantee, Old Republic, give them a call and just say your name and ask, did I purchase an owner's policy for my property? Okay? If you have a mortgage, guarantee you have a lender's policy. And in that HUD-1 statement, you can see here, section 1109 and 1110, that this person had indeed purchased a lender's policy and an owner's policy. Now, covered risks in both lender and owner's policies, they're the same. It says here that a covered risk is a defect in the title caused by forgery, fraud, undue influence, duress, incompetency, incapacity, or impersonation. Also, a defect in title caused by a document affecting title not properly notarized or acknowledged, witnessed, or sealed or executed. And also, a defect in the title caused by a document not properly filed or indexed in the public records, which would be in Hawaii called the Bureau of Conveyances. So the title company, their title abstractor in their title report was looking for these possible defects, because if they find a defect, they won't issue the policy until that defect is corrected. Okay? But if you close the escrow and you have an owner's policy and the lender's policy, the title abstractor is saying your title is free of defects, but it may not be accurate. So title insurance ensures the accuracy. So if you do find defects in title, according to the policy, you have to immediately notify the insurance company. Okay, so what you do is when you notify the insurance company under, as an example, this owner's policy, you have to provide proof of loss or damage, right? So the proof of loss or damage to title shall describe the defect in the mortgage, which is a lien, on the title or other matter insured against by this policy, which constitutes the basis of loss or damage, and shall state, to the extent possible, the basis of calculating the amount of the loss or damage. Okay. Now, in the case of an owner's policy, that amount, if it's pure loss, will cover the full amount in the insurance policy. So, as an example, $150,000 coverage will be paid. But if it's a lender's policy, then that amount would be determined what the debt is at that point when they found the defect. Okay. Now, there's also a 30-day window that the title insurance company has to do to fix the title or pay it off, according to the policy. So according to Falmouth National Bank versus Tycor Title Insurance Company in 1990, okay, this is regarding a lender's policy. The title insurance policy, they stated the title insurance policy in the Davis case, a previous case, provided that when presented with a claim of an adverse interest to the insured property, the insurer, the title company, had the option of pursuing a quiet title action without unreasonable delay or of paying any loss resulting from the defect. Regarding the timing of payment of the loss, the policy contained the same language as Tycor's policy, namely that when liability has been definitely fixed, the loss or damage shall be payable within 30 days. The court then on to state that in the lengthy opinion, the court held that the liability of the insurer was definitely fixed when it refused to take any action to quiet title. Thus, the court held that an offer of payment of the loss was due 30 days thereafter, but only after you have proof of title loss. So here's the diagram. Here we have the borrower and the lender, okay, the bottom right and left. Okay, the lender issues a loan to the borrower, right? And the borrower grants a mortgage or mortgages his or her property to the lender to ensure the repayment, a mortgage to the lender to ensure the repayment of the loan. But the borrower also purchases a lender's policy to protect the lender in case title to land is invalid and renders the mortgage void, or under an owner's policy, it pays off the owner the full coverage of that policy. So if there is a defect in title, then that would render the mortgage invalid. It would be like myself claiming I can borrow money and I can use the island of Kaho'olawe as collateral, that I can mortgage Kaho'olawe to the bank. Well, the bank would require me to go to an escrow company to determine whether or not I actually own Kaho'olawe. And if the bank says, if the title company says under its report that, oh, he does own Kaho'olawe, well, the bank will have the title insurance company will have to ensure the accuracy of that statement that I own Kaho'olawe, and a policy will be issued. Now, later on, if it's found out that that title abstractor that said I owned the property made a mistake, right? That means there's a defect in title, and that means what I mortgaged to the bank, Kaho'olawe, was nothing because I had no interest in Kaho'olawe. So what protects the bank and its promissory note or the debt that is owed to them is title insurance. Title insurance pays off the balance of the loan under the lender's policy or the amount covered in an owner's policy. The title insurance company may not have to pay off the loan or pay the amount covered in the owner's policy if they are able to fix the defect. And the title insurance policy authorizes the insurance company to fix the title. So when that Falmouth National Bank case refers to a quiet title action, that is a quiet title action instituted by the insurance company to fix the title. If they can't fix it, they got to pay off what is covered in the policy. So a lot of pressure on the title insurance company. Now, under the international law of occupation, the first rule is to maintain the status quo of the occupied country, its territory, laws, and citizenry. Second rule is for the occupying country to administer the laws of the occupied country through a military government similar to the American occupation of Japan from 1945 to 1952. A military government takes over an already existing governmental infrastructure in the occupied country by establishing a military governor. The third rule is that occupations are regulated by international law and not the laws of the occupying country. So what does Hawaiian Kingdom law say with regard to land titles? Not American law, which would include state of Hawaii law. What does Hawaiian Kingdom law say? Well, in the compiled laws of the Hawaiian Kingdom in 1884, which is the Civil Code, Section 6 says the laws are obligatory upon all persons, whether subjects of this kingdom or citizens or subjects of any foreign state, while within the limits of this kingdom, except so far as exception is made by the laws of nations in respect to ambassadors or others. The property of all such persons, while such property is within the territorial jurisdiction of this kingdom, is also subject to the laws, which includes real property. Well, here we have crown lands. Okay, crown lands make up about close to 1 million acres of Hawaii, which total acreage is roughly 4 million acres. And in 1848, a statute was enacted where it says that these lands, shy of 1 million acres, are to be the private lands of His Majesty Kamehameha III, to have and to hold to himself, his heirs and successors forever, and said land shall be regulated and disposed of according to his royal will and pleasure, subject only to the rights of tenants. Successors to crown lands are not the family of the monarch. It is rather the successors to the throne. So title was vested in Kamehameha III, but then it was transferred to Kamehameha IV, then to Kamehameha V, then to Lunalilo, then to Kalakaua, and then to Liliuokalani. And currently, title is vested in the Council of Regency as the successor government to the Queen Liliuokalani's administration. Now, under an act relating to the lands of His Majesty and of the government, okay, it set the stage for the crown, Kamehameha V, to approach the Hawaiian legislature for assistance to remove all of the mortgages that had been taken out on crown lands. So what the Hawaiian government did in the 1860s, I believe in 1865, a law was passed where they're going to sell bonds, and these bonds are going to pay off the loans, thereby releasing the mortgages or the liens, okay, which are called encumbrances on crown lands. But that statute would also create crown land commissioners. And these crown land commissioners shall have power and authority to make good and valid leases of said lands for any number of years not exceeding 30. Okay, so from 1865, all crown lands are limited to 30-year leases. That would apply today. Now, we also have government lands, okay, according to the Act of 1848. And these lands, numbering roughly 1.5 million acres, states here that it is made over to the chiefs and people by our sovereign Lord the King, and we do hereby declare those lands to be set apart as the lands of the Hawaiian government, subject always to the rights of tenants. And we do hereby appoint the Minister of the Interior and his successors in office to direct, superintend, and dispose of said lands as provided in the Act to organize the executive departments. So these government lands are going to be managed by the Minister of the Interior. And this is where people throughout Hawaii can acquire what is called royal patent grants. Now, all titles in Hawaii originate from royal patents and land commission awards. So here's an example of a royal patent issued to Robert Robinson, okay? And this property was conveyed to him, but reserving the rights of native tenants. And that is an important reservation because it's tied directly to the Great Mahele and native tenant rights for them to acquire fee simple title under Hawaiian law. Okay. And here's an example of a land commission award issued to J.P. Parker Ranch. And this was a land commission award that confirmed that Parker received in 1843 from Kamehameha III and the Prime Minister a title that resembled a fee simple title. So this land commission award verified that what Parker had in 1843 was a fee simple title. And this would allow Parker or his descent or his heirs or assigned individuals to convey property to other people. And this will start what is called a chain of title. Now, conveyances under Hawaiian law, all deeds, leases for a term of more than 1 year, or other conveyance of real estate within this kingdom shall be recorded in the Register of Conveyances. Okay, so that's the Bureau of Conveyances. Now, before it can be accepted as a bona fide deed okay, or transfer of title or conveyance, it has to be acknowledged by a notary, a Hawaiian Kingdom notary public. And according to Hawaiian law, it says here that no person who is not a subject of this kingdom shall be eligible to the office of notary public. So just as a deed conveying property to someone in California, under California law, you need to get it notarized. And that notary has to be a United States citizen, as well as a citizen of the state of California. Okay, and that's how that process works. So the same thing applied here, where notaries had to be Hawaiian subjects. Now, deeds of conveyance of real property and mortgages after January 17th, 1893 cannot be considered lawfully executed because the Register of Conveyances and Notaries Public were insurgents and members of the so-called provisional government and its successor, the Republic of Hawaii. President Cleveland acknowledged this when he stated to the US Congress after investigating the overthrow that when our minister, John Stevens, recognized the provisional government, the only basis upon which it rested was the fact that the Committee of Safety declared it to exist. It was neither a government de facto, in fact, or de jure in law, meaning they're not a government. Hawaiian Kingdom law was to be administered by the president through a military government in accordance with the Hague and Geneva Conventions, but it did not administer Hawaiian law, which is an obligation under international law. Consequently, this failure renders all conveyances of real estate and mortgages securing the repayment of loans within Hawaiian territory since January 17, 1893 to the present null and void. Be no different than me trying to get a deed acknowledged by a member of a criminal syndicate, claiming that that person is a notary. So here's a chain of title to real estate that kind of breaks it all down and hopefully brings some clarity to what I was explaining. So all titles originated in 1845 under the reign of King Kamehameha III. Royal Patent 1225 was issued by the Minister of the Interior to Daniel Collier. And let's say that Daniel Collier conveyed that property to another person in 1874 by going to a notary, getting acknowledged, and then recording it in the Bureau of Conveyances to show evidence that legal title has been transferred. And then that person conveyed it to someone else in 1884, someone else in 1894, another person in 1897, and another person acquired in 1975, which is the current property owner. Okay. The problem here is there's a break in the chain of title. Incompetent notary and registrar of the Bureau of Conveyances. Well, there's no treaty between the Hawaiian Kingdom and the United States where the Hawaiian Kingdom joined the United States and became a part of it, whereby American law can now be applied here, right? There's no treaty. So by not having a treaty in 1898, that rendered that conveyance done in 1975 by that notary under the state of Hawaii invalid. Now, we also have a problem because 1893, January 17th, the United States fails to administer Hawaiian Kingdom laws. So that conveyance made by the Republic of Hawaii, the predecessor of the provisional government in 1894, and then also by the Republic of Hawaii in 1897, some notary a person claiming to be a notary. Well, the fact that the United States did not administer Hawaiian Kingdom law, those conveyances are invalid as well. So here's an example of fraud by the provisional government that is recorded in the Bureau of Conveyances. This is the first royal patent grant out of government lands conveyed in February, just a month after the illegal overthrow of the Hawaiian Kingdom government. So if you notice here, the royal patent grant has Lili'uokalani by the grace of God, Queen, crossed out and handwritten Sanford B. Dole, President of the Provisional Government. And the grantee to this property is Cornwell. Okay? Cornwell is a trader. He used to be a part of Queen Lili'uokalani's cabinet, but he's a turncoat. And he purchased property in Holualoa. on the island of Hawaii. And if you also notice, Lili'uokalani's name there is lined out and handwritten Sanford B. Dole, President of the Provisional Government of the Hawaiian Islands. And where it says by the Queen, it's lined out as far as Queen and handwritten President. This is clear evidence of a defect, and anyone today in Holualoa that has a direct tracing of their property to this royal patent grant, they have a defect in title based upon fraud. And that is covered by title insurance. Now, evidence of proof of loss of title to property are covered in 2 reports by the Royal Commission of Inquiry. The preliminary report on the legal status of land titles throughout the realm, and also the supplementary report on title insurance. So it's all there. And if you go back to that blog article, I think it would make more sense now that I had covered that information with this PowerPoint. So let me turn it back to Kealii.
Okay, thank you, Dr. Sai. Question. Well, actually, not a question, but something that I saw in the beginning of your PowerPoint. There has been some confusion as to mortgage and the relationship of a mortgage to a bank and title. Does the bank hold title to the property when they loan the money?
No. So what the bank holds is a lien on the property. That means the borrower still owns the title or has the title. The borrower did not transfer the title to the bank. But there are states in America where you actually convey the title to the lender to secure the repayment of the loan. That's not the case in Hawaii.
Okay, so that's a reason for the foreclosure process, because the lien doesn't give the bank the title to the property, and so they're trying to secure the title back from the property owner, correct? Because the lien now, the mortgage only applies because it's a lien on the property itself, and they do not hold the title.
Well, in Hawaii, the title is not transferred to the bank by the borrower under a mortgage agreement. Right. But the mortgage agreement merely authorizes the bank to sell the property. In the case of Hawaii, because the bank only has a lien on the property and not ownership of the title, the mortgage authorizes the bank to foreclose on the property and sell that property on behalf of the borrower, who authorized the bank to foreclose if that person defaulted on the loan. So that's all stipulated in the mortgage agreement.
Okay. I just wanted to clarify that, because some people get confused in thinking that the bank holds the title, and they don't. No. At the time they purchase. Okay, so I have a question from Chaz tonight. He said, who's going to hold the fake state of Hawaii accountable for selling stolen Hawaiian land?
Well, that's another issue that doesn't apply to title insurance, right? Those issues are going to be dealt with in another way, right? But the state, if it didn't have any title to begin with, didn't convey anything. So it's not like the fake state sold land. You can only convey property if you actually own the property. The state of Hawaii doesn't have title to Crown and government lands. So I would recommend to read that preliminary report from the Royal Commission of Inquiry on the status of land titles in Hawaii. It explains that, right?
Okay. The other question is, the issue of land titles and the defect in titles has taken place over a long period of time, and you were the first one to bring it up with perfect title, and then we ended up having Laulima. What has changed to make this, and I guess, a better issue for people to now file claims? What's the difference between from the beginning to now?
Nothing. The insurance policies, irrespective of a political climate or chaos, a title insurance policy obligates the beneficiary of that policy, okay, to file the claim. So it's not a political game that should I file. If there's a defect in a title, you got to file. That's your policy. And by not filing after you know that there's a possible defect, it could affect you because the title company could use that against you that you didn't let us know in time, right? So the policy itself says if there's a defect, notify the insurance company, period. Now, in the past, until we got involved, nobody even knew they had defects in the title. So nobody had any reason to file an insurance claim with regard to the overthrow of the Hawaiian government in 1893 and the impact that it has today. Now, what ends up happening is back then, people were ignorant as to what Perfect Title Company was doing in the 1990s in exposing this and providing evidence to their clients so they can file their insurance claim. And all you had out there was just smearing of myself as one of the principals of Perfect Title Company and Donald Lewis, former owner of Locations Inc., to be attacked. And these attacks came as a result of the title companies headed by John Jubinski, an attorney for title guarantee, who was spreading rumors that were ripping people off, right? So because they could not refute the title reports that Perfect Title Company had provided their clients to show the defect in order to file the claim, the title companies decided that the only course they had was to smear and attack those delivering the message. That didn't change anything in the policy. That policy still says if you have information of a defect, you got to notify the insurance company. That's part of the policy, and that's the contract. But what they were doing was smearing us so people don't even believe what we're saying. And, I knew specifically they couldn't refute the title reports. In fact, Bruce Graham, an attorney from one of the law firms in Hawaii, okay, and also a professor at the law school that teaches land titles, admitted to me that he could not find anything wrong with our title reports. All he said was, well, America's here and that's just the way it is. That's not addressing a defect. It's a contract. That shows you the level of fear that they were at. And that led to the arrest of myself and Donald Lewis back in 1997 for racketeering, money laundering, and attempted theft. Yeah, full-on smearing, right?
Yeah. Yeah.
If I was that bad, I should have got arrested,
Yeah.
and put away. Well, they couldn't find anything, so they dropped it, and then they get us on attempted theft of property, which is another manufactured charge. And what's amazing is we weren't being prosecuted on fraud. We weren't being prosecuted on a conspiracy. It was on attempting to steal land. That's completely off. But, as time goes on and the dust settles, well, here I am with a PhD in political science, and I actually teach this at the University of Hawaii. And it's accepted because it is what it is. That's what the law is. I mean, it's not like Keanu made it up. But now putting in the context of title insurance, what people today did not have is the evidence or proof of the defect and loss of title. That's why that blog article is important, because it does provide people who have title insurance the means by which to file a claim. So it's no different than filing a claim because somebody banged your car, and according to your insurance you have to report that. Well, take a picture, right? Call the claims adjuster and say, hey, I got a dent. Well, that's what you're supposed to do with title insurance. It's not a political issue. You don't need to hire an attorney to go file a claim, right? You go hire an attorney later to collect on the money owed to you. And that's another issue because things are developing in that area that we did not have back then.
We've got another question from Pebs Wiedemann. And he said, does this title issue also cover those on DHHL?
Yes. The problem, though, is lessees of the 99-year lease under the Department of Hawaiian Homelands do not have an owner's title insurance policy or a lender's policy. Okay. When they may have taken out a loan from a lender. The state of Hawaii, Department of Hawaiian Homelands, is what guarantees the title. The problem is the state of Hawaii doesn't own anything. And the majority of Hawaiian homelands sit on crown lands. Okay. So that means that those leases are invalid because it came from a state of Hawaii who's a direct successor of the provisional government. Right. Now, remember that deed that I showed you where it said reserving the rights of native tenants, right? And also crowning government lands. In the statute, it says reserving the rights of tenants. What that means is, although title on crown lands can only be issued no more than 30 years as far as a lease. But if that individual on Hawaiian homelands, because they're already a Hawaiian subject and they're a native tenant, they're Aboriginal Hawaiian, they come under vested rights that were part of the Great Mahele of 1848, that the Crown had committed that whenever a native tenant desired a fee simple title, he could approach the Crown and get it. So in this case, Hawaiian homesteaders, your lease to 99 years is invalid, but the remedy to that defect is a fee simple title called a kuleana. Yeah. And that is important to know. So that's also covered in that preliminary report by the Royal Commission of Inquiry on land titles.
I think one of the questions that, well, it's not a question, but the reality of living on Hawaiian homelands is the first thing that they should be asking Hawaiian Homes is whether or not they have title to these lands in order to lease it out in the first place.
Yeah, well, in this particular case,
yeah,
if a homesteader has a loan on the property, right, borrowed money, and the state of Hawaii is the one to guarantee that if there's a defect, right, the state of Hawaii will have to pay off the loan. So the state of Hawaii acts as if they're the insurance company. Well, borrowers who are homesteaders can actually send that letter, right, that is on the blog to their lender under the lender's policy. You may have to adjust it slightly.
Yeah.
But just notifying them that the state of Hawaii doesn't have title to this property. There's a defect. Therefore, I have a defect. So the state of Hawaii should be paying off my loan because they're guaranteeing the title. Because they're supposed to have the fee simple title.
Another question coming in from Momi Sales. Many people did not know that their titles were defective. Would that in itself be considered fraud? Title insurance, realtors, the state, Better Business Bureau.
Well, strictly from the policy perspective, there are certain covered risks, right, in the coverage of title insurance. And one of those covered risks is fraud. But it's fraud with regard to your title, not with regard to
any individuals.
Or
individuals.
That could be considered what is called a tort, right? Subject to legal proceedings, but that is a completely different issue.
Okay. Josie Carson said, is there any resolution for families that already got foreclosed upon and probably had title insurance at that time.
I recommend that you read the Royal Commission of Inquiry's supplemental report on title insurance, because it explains there that when a person purchases an owner's policy, right, that policy is still active, even though the title may have been transferred, whether by foreclosure or that person conveyed the property to somebody else. And the reason why that owner's policy is still active is there is what is called a warranty. Okay, and that's where you get that title of the warranty deed. So what a warranty is that the person conveying the property to someone else, although they transferred it, they will warrant and defend that property against any defects. That means that that person in the chain of title that goes all the way back to 1845, if they had purchased an owner's policy in that chain of title, irrespective of the time, that policy is still valid because that person is still liable in that chain. So that coverage in that owner's policy, let's say back in 1980, you bought a property and you bought an owner's policy for $500,000 coverage, right? And then later you sold that property to somebody else, let's say 10 years later, that insurance policy did not terminate. It's still active. Now, the only policy that would terminate would be the lender's policy after the loan has been paid off. Then the debt has already been covered, so there is no lender's policy. But an owner's policy continues, and that's covered in the supplementary report.
Okay, Ekahi Brewster sent in, is the Great Mahele a Hawaiian national right? This regards the difference of nationality, Hawaiian national or American national.
The Great Mahele, which is covered in the preliminary report, okay, does not apply to nationality, but rather a process by which chiefs of the nobility class at that time, the government, and the native tenants of the commoner class would be able to divide out their interest in the land into a fee simple title. Okay, that's what mahele means. So the Great mahele is to divide. So the Great mahele is to divide what was formerly undivided, meaning collective, mahele ole, right? But mahele is to divide, and the Great Mahele of 1848 was the beginning of establishing that process by which the chiefs would divide out their interest to get a fee simple title to an ahupua or an ilikupono, right? These are subdivisions of land as chiefs. But also, after that's done, commit to dividing out with native tenants in that ahupua or in that ilikupono for their fee simple title, which would be for their house lot and pasture lands, or lo'i, right? That has since evolved where clearly, under the 1850 Kuleana Act, right, native tenants can actually go directly to the Minister of the Interior to acquire up to 50 acres at 50 cents an acre, up to 50 acres, which according to the inflation calculator, because that law still is valid, would be $17 for an acre. No, that's still law.
I think we can afford that.
Yeah, but
that's affordable.
But what it does is it's what Hawaiian law says with regard to real estate. And people in Hawaii were not educated on Hawaiian history because people were led to believe that Hawaiian Kingdom was controlled by the Haoles and the missionaries created it. It's all false. I mean, you even have Hawaiian academics that claim what happened in the Hawaiian Kingdom was not our system, that was the foreigner. No, that's all made up, right? But here we are looking at people now who aren't at the university taking these classes that are just untrue. Here you are with the title insurance policy. See, now you're directly affected by this information. So it's important that people read over carefully that latest blog article, as well as read over carefully the reports, preliminary report by the Royal Commission of Inquiry on Land Titles, and the Royal Commission of Inquiry's supplementary report on title insurance.
Okay, Momi Sales has wanted to clarify. She said, I mean, who were we supposed to trust? This stuff is not taught in schools, nor told by banks.
It's not a matter of trust. It's just the policy says as soon as you are aware that there are defects in your title, you have to notify the insurance company. That's all it is. This is not something that needs to be made complicated. So if you have an owner's policy, right, file a claim. That's the key. If you have a lender's policy that you purchased for the bank, send the bank that letter that you can download from that article, notifying them. That's the first step. So this is not about trusting anybody. It's liability, and it's tied directly to everyone's individual contracts. This is not a Hawaiian issue. Title insurance applies to anybody who has an insurance policy, irrespective of your nationality or ethnicity.
Okay, Kalaupea, all the way from Nevada, sends irrefutable title reports. You struck a chord because you spoke about the number one asset the occupier claims they have title to. I guess it's a statement that he made. Any comment to that? No?
Just read the title. Just read the preliminary reports of the Royal Commission of Inquiry as proof of title loss.
Okay.
With regard to the insurance claim.
Okay. Next question by Ches tonight. How do we stop the selling of the land? The Regency doesn't have control of the fate state.
The selling of property can only occur if you actually have a valid ownership. I can't go and sell your property, Kealii, because I claim to own it, right? Because you're on the record as supposedly owning it. Mm-hmm. But you realize that there's a defect. But I can't go out and sell everyone's property that I have no interest in. The state of Hawaii has no title, so nothing has been conveyed. So despite the fact that titles are claimed today by people throughout Hawaii, it's still invalid because nobody can transfer it after 1893. That's not a political statement. That's just that's the fact.
And I think one of the problems is that realtors fail to disclose that titles could be defective to the buyers. That's one of the big issues.
On that note, that's another issue that has nothing to do with title insurance. If a realtor sells a person a property and that realtor knows that there is a problem with the title and they did not disclose in the DROA form that there's a problem with the title, that person who bought the property finds out that there is a problem, can actually sue that realtor for failure to disclose. Yeah. But that's not title insurance. That's just liability.
That's liability. Yeah.
Within the real estate industry for realtors and brokers.
Okay, Isaac. Maha ku'elua. And aloha, Isaac. Mahalo for watching, bro. If a homeowner proves a defect in title and the title insurance company pays off the loan, will the homeowner get kicked out from their home because they prove that they really don't own their home?
Good question. No. People acquired property today, majority in good faith, right? They paid money for something, or there was some valuable consideration exchanged, whether $1 in love or under a bill of sale for $10 million, right? What that does is it provides people today the first right to remedy their title, unless those titles were derived clearly in violation of law, right? So every title is different, but for sure, all titles in Hawaii that were transferred after 1893 are invalid because of a notary. But again, the preliminary report that I want to keep stressing, it explains all of that, not just the defect, but also how to fix the titles. That's what's important.
Okay, Kalaupea submitted a question. Since yesterday was July 4th, and the joint resolution was passed July 4th, 1898, can you explain why a bill has no jurisdiction to cede lands to America?
Well, the joint resolution wasn't July 4th, it was actually July 7th
Okay.
in 1898.
Okay.
Now, the joint resolution of annexation is an American law enacted by the House and Senate. That's why it's called a joint resolution, and signed into American law on July 7th by President McKinley. That makes it American law. American law, right off the bat, has no effect outside of its territory. So it did not annex anything, even though it said it did, right? So the only way that American law can apply to Hawaii after 1898 was if what occurred in 1898 was a treaty whereby the Hawaiian Kingdom government transferred itself to the United States. That never happened. There is no treaty.
Okay.
There's protests on an attempt to do it by a treaty with the self-declared Republic of Hawaii, which were the insurgents. And that's the Hawaiian Patriotic League, the 21,000 signature petition. Basically, it killed the treaty. And it forced the Congress to come up with another way, deceitfully, to claim that Hawaii was annexed because we passed a law saying we annexed you. The United States could no more pass a law annexing Hawaii, a foreign country, than the United States can pass a law today annexing Canada, annexing Mexico, annexing Japan. Laws of America are limited to territory of the United States. That's how it works, right? And that's not an argument. So it's not a political statement. It's just the limitation of American law. So in the absence of any acquisition of the Hawaiian Kingdom's territory by the United States by a treaty, it is supposed to administer the laws of the occupied state, in this case, the Hawaiian Kingdom law. It hasn't, because they were hiding it, because they took Hawaii in 1898 and they tried to justify it amongst themselves as a military necessity during the Spanish-American War to seize Hawaii and military build it up to protect the west coast of the United States. Those are just facts of as evidence of violating international law. It's not like the United States has to give back Hawaii. The United States never had it. And that's what the law of occupation is able to explain, which could not be explained in the past with other theories.
Yeah. Okay. Ches Kanai has another question. If the original royal patent and it's still in my family name, how do I get it back into my family's control if someone else is on it?
Okay, so the royal patent is just a template of a deed that the Hawaiian government conveys title, right? Now, once a person receives the royal patent that has been recorded in the Bureau of Conveyances by the Hawaiian government, that person who received that deed does not transfer the deed, the royal patent, to somebody else. What that person would do is draft a warranty deed that draws from the property of the royal patent, whether in its entirety or a portion of it, and record that warranty deed in the Bureau of Conveyances. And then that person, if they want to convey their interest to someone else, will also record a warranty deed in the Bureau of Conveyances showing the evidence of a transfer of title. When somebody sees a royal patent with the royal seal on it, the red wax, that is not proof of ownership of property. That's just an heirloom. You can frame it, right? You would have to look into the Bureau of Conveyances to determine whether or not that person or its heirs conveyed the property. And that's what is called a chain of title. And that's what is evidenced in the Bureau of Conveyances. And that's what title abstractors and escrow companies are looking at. So all titles today originate from royal patents and land commission awards. Not that the land commission awards and the royal patents as a document was given to other people, and it kept going down the chain. That's not how titles work. The same thing would apply in California. Titles, the original titles in California are called Spanish deeds or Spanish patents, right? Now, once a person received a Spanish patent in Mexico, they would convey a deed, not the patent, to someone else. And that would be transferable, right? And then that Spanish patent would become an heirloom in that family's possession. Right? The same thing would apply here in Hawaii.
Okay, Pebs Wiedemann has a good question. So if we do step one by notifying both owner and title insurances, and both say there is no defect, does the Council of Regency have lawyers we can utilize to move on to the next step?
What's important is you got to follow the steps that are laid out in that blog article to provide the necessary information. But it's also giving the opportunity for the insurance companies to fix the title, right? And that's explained how you fix the title in that preliminary report on the status of land titles in Hawaii. Now, once they receive the proof of loss of title, which is in the preliminary reports that you're supposed to include, that is included in the letters, okay? Once they receive it, what will happen is when they receive an insurance claim, the insurance company will send you a letter acknowledging receipt of that claim and assigning it an insurance claim number, and say they are looking into it. Once you receive that letter acknowledging receipt of your claim of proof of no title, they have 30 days, the 30-day window, to remedy the problem. Not saying there is no defect, they got to remedy the problem. They have to counter everything that is stated in the claim, in the evidence. And if they don't do it within the 30-day window, a person with an owner's policy can file a lawsuit later to collect, right? It's really just initiating that 30-day window so that you give the insurance company the opportunity to fix the title in accordance with the preliminary report from the Royal Commission of Inquiry on how titles are fixed. Now, these insurance companies are not here. They're in America. And they acknowledge that titles in Hawaii all go back to raw patents. And what basically the title insurance companies are supposed to do is to show that the Hawaiian Kingdom no longer exists. As part of the explanation in that article, also included as part of the claim is what is called another report by the Royal Commission of Inquiry on the Lorenzo Doctrine, where the Lorenzo Doctrine, the federal courts, by applying international law, have already acknowledged, whether they say it or not, have already acknowledged that the Hawaiian Kingdom continues to exist unless there is evidence to show that it doesn't exist. In fact, that very issue of the Lorenzo Doctrine was actually addressed by a senior claims counsel, an attorney, for Chicago Title Insurance Company, which is part of the Lorenzo Doctrine preliminary report. And they're saying that the United States no longer recognizes the Kingdom of Hawaii. And he cites 2 state of Hawaii court cases and a federal case. These 3 cases are what is known as applying the Lorenzo Doctrine, but they applied it wrong, right? And that's fully explained in the preliminary report. So what we're doing here is, I'm not advocating for everybody to collect on your insurance. The policy says you must notify. And if you have proof of loss and you send it to them, that would trigger the 30-day window. And leave it up to the insurance company to fix the problem, right? Now, if they can't fix the title, cannot fix the title, according to Hawaiian law, they got to pay you. Now, whether they deny paying you beyond the 30 days, as long as that 30-day window was triggered, you can go after them later on. for payment, and you got to file a suit, a breach of contract, in a federal court in America, where these title insurance companies are. And that's why you need an attorney that understands the Lorenzo doctrine that applies to federal lawsuits where the Hawaiian Kingdom is not in question. It does exist because it did exist. The insurance company will have to say or show evidence that it doesn't exist. If they can't, it exists. Next step, breach of contract, collection.
Okay,
But
follow up.
But that's down the road. This article is talking about filing a claim.
Okay.
That's all it is.
Follow-up question is, how does a title insurance go about fixing the title?
Read the preliminary report. There's a way to fix it. So if it's property on lands, let's say in Waimanalo, a fee simple owner claims to own property in Waimanalo, that's Crown land. If that person is not a native Hawaiian or Aboriginal Hawaiian, they can't get a fee to remedy. They would have to get a 30-year lease. And that would have to come from the entity vested with authority to convey property, which would be, in this case, the Council of Regency as the successor to Queen Lili Okalani's administration, who also had the Crown Land Commissioners for Crown Lands. That is all explained there. And the remedial part of fixing titles, okay, is clearly indicated in that report. So this does not mean that everybody who is going to file the insurance claim needs to understand how titles work. That's why you go to an escrow company to do this, to have a title abstractor, but the policy is issued. Okay, so claimants, people who have title insurance, follow what is recommended in the latest blog entry on making that claim. This is not a political claim. This is just a consequence of an illegal occupation that has lasted over 100 years and how it has a direct effect on your property. So it's not a question of should I or shouldn't I? If you have evidence, you're supposed to notify the insurance company. The blog article really provides the evidence to support your claim and leave that up to the insurance company to try to fix. If they can fix it, perfect. If they can't, they pay. It's that simple.
Okay, a couple more questions. This is from Ekahi Brewster, another one. Sounds like the problem is the state of Hawaii. How do we stop the provisional government during occupation?
That's another issue. I've covered that in other write-ups and other presentations. This one is focused on title insurance.
Okay. From last question, Marshall Baji. Current sales of real estate that have title defects are causing costs of properties to inflate, having negative effects on costs of property taxes by the counties and state. What can be done to cease this practice? To cease and desist this practice?
Well, the first step is making people aware of what's going on. So I would recommend sending that link to that blog article to every and any person you think needs to know that information, whether they're realtors, whether they're officials in Hawaiian homes. But this topic here is tied directly to title insurance, irrespective of whether the person who has the owner's policy or lender's policy is a Hawaiian subject or not. Anybody with the policy that I'm pointing out, you're supposed to file an insurance claim. That's what this is about. Now, granted, there are bigger issues, there are consequences, there are direct effect, there's a direct nexus to 1893. That's all in the preliminary report and the supplementary report and in the letters. But that's for the insurance company to look at, because they're going to give it to their attorneys, right? The first thing is your job is to send in your claim.
File the claim, yeah.
Just file the claim. That's what this whole thing is. It's not like, taking care of the problems of Hawaii's occupation. No, it's a policy that you paid for. You paid a premium for that coverage. If information has come to you, which if you read the blog article, it did come to you, then you're supposed to file the claim. This is just following what the contract says. And you benefit by either them fixing the title or them paying off the coverage in the policy to you. And then another process will have to take place to fix your title. And that will be done as part of the transition that is going on, where the United States will need to comply with the law of occupation. That all comes into play. Nobody's going to be left with defective titles, but they have to know that their titles are currently defective if it originated from properties that were transferred after January 17th, 1893. If an entity or family still has, let's say, Kuleana land that has been in that family since 1850s and nothing was transferred after 1893, that title is not defective. Also included would be like Kamehameha schools, their properties that they acquired under the will of Bernice Pauahi Bishop, under her will. Those titles are not defective. But if Kamehameha schools conveyed a portion of their title after 1893, they're defective because of the notary, not if it wasn't transferred prior to 1893. So those issues are important, and it's covered in the preliminary report. Yeah.
Okay, well, I think we've covered a lot of territory on this one, and this has been a really, really good. We're only scratching the surface on this, and I'm sure there's going to be a lot more questions, coming out of this, and we'll have more discussions in regards to this.
Well, Kealii, again, what I recommend is people have to read the information in order to know what to do, right? So this is not trying to get people to do something that is not in line with their own contracts. I'm here just to explain it. I'm not a part of any of these contracts. I don't benefit from it, but it is a consequence of what happened in 1893 to where we are now. So there is nothing complicated about filing a claim. It's just the information you have in that claim, which there is a recommended draft of a claim that people can use, right? That's all it is. I mean, if you don't want to use it, don't use it. I mean, it's up to you, whoever you are that has a policy or a lender's policy in your opinion.
Let me stick in real quick, just one final question, because I think this is important. And this is from Ches Kanaka. It says, what about all the TMK? TMK properties, they should have never been chopped up and sold, ? Right? TMK properties.
TMK.
Yeah, tax map keys.
Okay, so a tax map key is merely identifying fee simple owners on a property. So here's an example of what will happen when somebody acquires a raw patent 155, I'm just making it up, right, to Joe Smith or Joe Kealii, okay, and it comprised of 50 acres. On the tax map key that the counties use to identify ownership of property with regard to property taxes, you will see raw patent 1153, right? And it's kind of big. But then you'll see portions of it with different TMK numbers, tax map key numbers. That's because those titles originated from the raw patent. But instead of the person with that raw patent conveying the entire property to somebody else, they may have only conveyed an acre of that property or a quarter acre. You can't do that. That's recorded in the Bureau as a warranty deed. So the collection of these deeds are not subdividing the raw patent. It's just identifying the origin of title that says this is a portion of what was considered raw patent 1153. But that particular chain of title will reflect that and what was conveyed. So every tax map key number is a reflection of that person or entity claiming ownership to the property by a deed or by a probate proceedings, or by a white title action, whatever the case is. But it all will show through a chain of title going back to raw patent 1153. So it's not subdividing the raw patent. No, it's just a reflection of who has what. But every parcel, every tax map key, a portion of that raw patent has its own title report. They're all not the same. And that's why title abstractors are able to track that. I used to be a title abstractor. I used to train them. So I understand that very, very clearly how it works. So I hope that help explain what it is.
It does. It does.
Yeah.
And again, mahalo piha for joining us tonight, Dr. Sai, and explaining this important information that everybody should know, about title insurance, especially homeowners and anybody that owns property needs to understand the importance of the title that they have and the defects that.
Oh, I just want to add one more thing, Kale.
Sure.
People that own title insurance policies also include not just those claiming fee simple title, but also leasehold properties. So commercial leases, long-term commercial leases, you might have a title insurance policy because your lease is only as valid as the lessor's fee simple ownership, right? And that's what created the lessee's possession. But not just fee simple owners have an owner's title insurance policies. Even commercial leases. So those who are companies, you could take a look. Maybe call your the escrow company that you borrowed money using your lease property as collateral with the consent of the lessor. Check if you have title insurance. This filing of a claim would also apply there.
Okay. With that final word, again, mahalo, Dr. Sai. I really appreciate you being with us.
No problem.
Okay, everyone. I really appreciate you joining us tonight. And do your homework. Go back and pull up the HawaiianKingdom.org blog, the latest article that Dr. Sai, the Council of Regency, posted, and also go to the other book that he referred to that you can get information about, because it is very important that we know it, we learn it, and we implement it. Because that's the way that we're going to be able to not only protect our properties that we have, but also help the Hawaiian Kingdom and the government be restored. Because if many of us start to file claims, and the moment that title insurance companies start making payments, because they would have to research whether or not why the titles are defective. And this is one of the major issues that the government, the state of Hawaii, as well as the real estate industry and the banking industry were so afraid of, because they know that the titles in Hawaii are defective. And This has been a lie ever since 1893 up to present. And that glass house that they built will begin to crumble. So do your homework out there, make it count, and if you own property, file a claim with your title insurance company under the owner's policy. And if you still have a loan on it, file the claim with your bank, because the bank is the insured that has to file the claim. You have to notify the bank to get the bank to file the claim with the title insurance company. So with that, I'd like to big mahalo to Lynn Cox for an awesome show. And again, mahalo piha to Dr. Keanu Sai. And next week, we should have a pretty good show for you. I'm not sure who the guest is coming, but we're working on it, and it'll be really good. Until then, mahalo for joining us, and a hui ho.
Uama ke ao kaina I ka pono o Hawaiian. Uama ke ao kaina I ka pono